As Malvika said, I'm Sneha Phene, and I'm today going to explain the concepts of venue and seat in arbitration. I want all of you to imagine a scenario where there are two companies. One is based in New York, and the other is based in Mumbai. They have a contract between themselves, and they agree to arbitrate if there is any dispute in the contract. The arbitration clause says that the venue of the arbitration will be Paris and the seat will be Singapore. So now the question is, which law governs the arbitration procedure? This is the question which we will be answering or trying to answer today in this lecture. So the objectives of this talk today are first to understand the legal significance of seat and venue, to differentiate their roles in domestic and international arbitration, and to apply key Supreme Court rulings in deciding how to interpret arbitration agreements. So first of all, we go straight to Section 20 of the Arbitration and Conciliation Act 1996, because this is the provision from which the concepts of seat and venue emanate as far as Indian law is concerned. Okay, now this is quite important, so I'm going to read the section, which you can also probably see on your screens. Section 20, place of arbitration. The parties are free to agree on the place of arbitration. Just see, I have highlighted the word place wherever it appears in the section. Subsection 1 says the parties are free to agree on the place of arbitration. Subsection 2 says, failing any agreement referred to in subsection 1, the place of arbitration shall be determined by the arbitral tribunal, having regard to the circumstances of the case, including the convenience of the parties. And then subsection 3 says, notwithstanding subsection 1 or subsection 2, the arbitral tribunal may, unless otherwise agreed by the parties, meet at any place it considers appropriate for consultation among its members, for hearing witnesses, experts or the parties, or for inspection of documents, goods, or other property. Now, if you see, the same word place has been used in all the three subsections of section 20. So therefore, it appears that there is some sort of contradiction. Because on one hand, subsections 1 and 2 say that first, parties have the right to agree on what the place of arbitration will be. And then they say if the parties have not agreed, then the arbitral tribunal will decide what the place of arbitration shall be. But then subsection 3 says, even if they have decided, either the parties or the arbitral tribunal may meet at any other place, and as it considers appropriate. So a question may arise as to what is this contradiction? What is the point of deciding upon a place of arbitration if the arbitral tribunal is free to meet at any other place, right? So it seems a little dichotomous. So is there really a dichotomy? The answer is no. This is because though the same word place is used in all the three subsections of section 20, the word place in subsection 1 and subsection 2 refers to the seat of arbitration, while in subsection 3, it refers to the venue. Okay, so this is what we say, subsections 1 and 2 focus on the seat, and subsection 3 allows hearings at any venue. So now, this is what has been interpreted by the Supreme Court in the case of Balco versus Kaiser Aluminium Technical Services Limited. The Supreme Court says this, that subsections 1 and 2 focus on seat, subsection 3 allows hearings at any venue. So the effect of section 20 is this, that the parties have the first right to determine the seat of arbitration by agreement among themselves. If they do not decide, the tribunal decides the seat. But depending on the circumstances, the tribunal may decide to hold hearings at any venue, which also may be different from the seat of arbitration. So this takes us immediately to the concepts of seat and venue. Now, what is the seat of arbitration? Seat of arbitration could be said to be the juridical home of the arbitration. This is the place where the arbitration is anchored, where the arbitration lives juridically. So why is this concept of seat important? It is important for two reasons. In international commercial arbitration, the seat of arbitration is important because it determines the procedural law which will govern the arbitration. Now, what is this procedural law? There are several procedures which are contained, for example, in Part 1 of the Arbitration and Conciliation Act, which govern, for example, interim measures or give power to the court to support the arbitration, to assist in arbitration which has run into difficulties. For example, for filling of a vacancy in the composition of the arbitral tribunal. Or they provide for the supervisory jurisdiction of the courts over arbitration. For example, removal of an arbitrator for misconduct. So these are procedural rules, and if a seat has been chosen, the procedural law of that particular place, which is the seat, will be the procedural law by which the entire arbitration will be governed. Now, if you remember the example which I started with at the beginning of the lecture about a Mumbai-based company and a New York-based company entering into a contract and choosing Singapore as the seat. So if the parties have chosen Singapore as the seat, the law at Singapore will be the law which will govern the arbitration procedure. So the procedural law at Singapore will be the law which will govern the arbitration in this case. So now, if one of the parties wants some interim relief and it approaches the Bombay High Court, will the Bombay High Court have the jurisdiction to decide this application and to grant interim reliefs? The answer again is no. This is because the seat gives exclusive jurisdiction. When a seat is chosen, it gives exclusive jurisdiction to the courts which have jurisdiction over the seat of arbitration. Now, parties often in international arbitration choose a neutral venue as the seat of arbitration. What is the reason for this? This is to avoid the feeling of bias, to ensure impartiality, to avoid jurisdictional bias. Thus, in this case, suppose a Mumbai-based company and a New York-based company have an arbitration going. Suppose they have chosen Mumbai as the seat of arbitration. So whenever interim reliefs are required, the Mumbai-based company approaches the courts at Mumbai. Then the New York-based company might get the feeling that, because it's home country, maybe it is more familiar with the courts here. Maybe it is possible that the courts would be, more in favor of a party which belongs to its own jurisdiction. This may or may not be true, but that is the feeling. So that is the reason why a neutral venue is chosen generally in international commercial arbitration. In the case of Balco, which I referred to earlier, the Supreme Court said that the venue, the seat gives exclusive jurisdiction and rejected the concept of concurrent jurisdiction. So once a seat has been selected by the parties or it has been determined by the arbitral tribunal, then there is no question of any other court having jurisdiction. It is only that one particular court which will have jurisdiction over this seat that will have jurisdiction over the arbitration proceedings. Now, why is the concept of seat important in domestic arbitration? So before we get to that, we see here that in international arbitration, the choice of seat has a clear legal significance. So is there a legal significance in domestic arbitration also? The choice of seat, does it have some legal significance in domestic arbitration? That may not be so. In domestic arbitration, there is not really a legal significance because the law which will apply will be the Arbitration and Conciliation Act, Part 1, all throughout India. So whether you choose Mumbai or you choose Delhi or you choose Jaipur, the same procedural law will apply. But the difference is that it will affect the convenience of the parties, right? The seat which is chosen will affect the convenience of the parties. So if a party is situated in Mumbai and there is another party which is situated in Delhi, and Delhi is chosen as the seat of arbitration, then necessarily if there is any application which must be made, that will have to be made in Delhi. So that is obviously convenient for the parties at Delhi. It is less expensive. It is easy, efficient for them. For the parties situated in Mumbai, it is a little more difficult. So that is the significance as to why the seat must be chosen carefully by parties in domestic arbitration. It's only for the purposes of convenience, but that is also a very relevant consideration in determining as to what is the seat which should be decided upon when parties enter into a contract. Now, if the seat is clearly mentioned in domestic arbitration, then the court having jurisdiction over this place where the seat is located would have supervisory jurisdiction over the arbitration proceedings. In some cases, the seat is not decided upon at all. Then in that case, Section 21E of the Arbitration Act can be looked at, because Section 21E tells you which courts would have jurisdiction in case in case there is no specific seat decided upon by the parties. Then Section 21E would apply. Now we come to the concept of venue. What is the concept of venue? Venue is only the physical location where the hearings are held. It can differ from the seat for practical reasons. Sometimes parties may decide that the arbitration should be held at a particular venue, but then the circumstances may change and they may find that it is more convenient to hold the arbitration at another venue. So, for example, if there is a natural disaster in a place or there is some political instability, then parties may decide that instead of holding the arbitration hearings physically at a place which we had decided upon, since there are some difficulties with that place, let us hold the arbitration at some other place. So in the Mumbai-New York dispute that we were talking about, where there was the venue, as we said earlier, was chosen as Paris, but the parties may decide that maybe Dubai is more convenient because it is centrally located. It is better for both of us. So therefore, they may decide on Dubai for whatever logistical reason. So that is permitted. And in spite of this, when as many times as the venue may change, the seat remains the same. The seat will not change. So one of the important cases in this is the decision of the Supreme Court in the case of Videocon Industries Limited versus Union of India in the year 2011, where, as per the contract, the seat of arbitration was Kuala Lumpur in Malaysia. The arbitral tribunal fixed a hearing at Kuala Lumpur, but then there was an outbreak of the SARS pandemic or the epidemic. For this reason, the arbitral tribunal shifted the venue of its sittings. First, it held its sittings at Amsterdam, then it held its sittings at London. And the Supreme Court held that merely because the hearings were held in Amsterdam or they were held in London, and the seat which was decided upon by the parties, that is Kuala Lumpur, did not change. The seat remained the same. It only meant that the arbitration has been held at a different venue. So now that we have seen this distinction, you might feel that this is pretty straightforward, right? Because, I mean, these are very distinct concepts. So there is nothing difficult about it. But in practice, there are several complications which may arise. If we look at Section 20 again, we see that the Act gives the first and foremost importance to party autonomy by saying that it is the party's first right to decide upon or to agree upon the seat and also the venue. So how is this agreement of the parties determined? This is determined by construing or interpreting the clauses of the contract. Now, this is where the complications begin. Parties very often do not clearly specify where they want the seat to be and where they want the venue to be. So then, when it comes to deciding upon what is the seat of arbitration or what is the venue of arbitration, the courts have to interpret the agreement and decide what the parties intended the seat to be. So let us now consider how the courts have interpreted the contract in different cases. The first case which we can consider, is the case of Balco, which was the landmark decision of the Supreme Court. It was a constitution bench of the Supreme Court which decided this case in the year 2012. In the case of Balco, the Supreme Court said that the Part 1 of the Arbitration Act 1996, which governs arbitral procedure, will apply only if the seat is in India. The Supreme Court said in this case that if the seat is outside India, then the procedure of that seat will apply, and exclusive jurisdiction will be given to the courts of that seat. Now, this was a change from what the Supreme Court had decided earlier, because earlier in the case of Bhatia International or in the case of Venture Global Engineering, the Supreme Court had said that the parties could choose to apply Part 1 of the Arbitration Act in international arbitration, even if the seat of arbitration was outside India. But BALCO overruled Bhatia International and Venture Global Engineering and said that Part 1 of the Arbitration Act will apply only in cases where the seat is in India. So BALCO therefore emphasized on the principle of territoriality, that is, which is really a principle which has been adopted from the Uncitrol model law. That is, that the law of the place which is decided as the seat will be the law which will be applicable. Now, there is also a very interesting observation in the case of BALCO, where the Supreme Court said this, that suppose the parties have clearly chosen in an international arbitration the seat as someplace outside India. In such case, even if the parties have specifically stated that the Arbitration and Conciliation Act 1996 will apply, that does not mean that Part 1 of the Act will be applicable. And that will not enable courts in India to exercise supervisory jurisdiction over the arbitration. What the Supreme Court said is, in this case, certainly the mandatory provisions of the law at the place of the seat will apply to govern the arbitration proceedings. It may be considered by the court that the provisions of the Arbitration and Conciliation Act, which do not conflict with those mandatory provisions of the seat, are applicable. So therefore, it could be that the internal rules of the arbitration could follow what the Arbitration and Conciliation Act says. But insofar as there is a conflict between the Arbitration and Conciliation Act and the law, the procedural law of the seat of arbitration, the procedural law of the seat of arbitration will prevail and not the Arbitration and Conciliation. Then the next case we come to is the case of Indus Mobile Distribution Private Limited versus Datawind Innovations Private Limited, where the Supreme Court said that choosing a seat of arbitration is akin to an exclusive jurisdiction case. So it said that the court having jurisdiction over the seat will have exclusive jurisdiction even if the seat is elsewhere. And this court also clarified that choosing of a seat of arbitration amounts to giving exclusive jurisdiction even if that place is a neutral venue. That is, even if there is no part of the cause of action which has arisen there. This is even in a domestic arbitration. So the Supreme Court here said that if the parties, one party is in, for example, in Mumbai, another party is in Delhi, the cause of action might have arisen partly in Mumbai, partly in Delhi. In spite of that, the parties could choose probably, say, Ahmedabad as the venue, because that is a neutral venue. So even that is permissible in a domestic arbitration as per the decision of the Supreme Court in the case of Indus Mobile Distribution Private Limited versus Datawind Innovations, where the Supreme Court said, interpreting the case of BALCO, that this is the necessary inference from the decision in the case of BALCO. And the Supreme Court said that as per Section 21E of the Arbitration and Conciliation Act, in such a case, the court within the jurisdiction of which the arbitration is located, that is the court having jurisdiction over the seat of arbitration, would be the court where the applications under the Act would have to be made. So this again is an important principle which was put forth by the Supreme Court in the case of Indus Mobile. Then we come to the Shashwa principle. In 2017, there was a case in the Supreme Court called Roger Shashwa versus Mukesh Sharma. Now, this case was preceded by another case before the Queen's Bench in London, where again the party was Roger Shashwa, where the Queen's Bench had applied a principle in determining what the seat should be if there is no express designation of the seat given by the parties. So this is now commonly known as the Shashwa principle. So What exactly did the Queen's Bench division say? It said that suppose there is no seat specified specifically in the arbitration agreement, but the parties say that the venue should be so and so, and there is nothing which is contrary to the intention of the parties to decide to show that the venue which they have said, which they have specified, should not be the seat of the arbitration. If there are no significant contrary indications, then the court would decide that the venue which the parties have decided upon would be the seat of arbitration. So, though the parties have used the word venue, the court said that actually what the parties intended was to designate the seat of arbitration. This is known as the Shashva principle. So, this was first applied by the Queen's Bench, and then in the later decision by the Supreme Court in Roger Shashwa versus Mukesh Sharma, this principle was accepted. Then we come to the decision, which is again a very important decision in the case of BGS SGS Soma versus NHPC Limited of the Supreme Court in the year 2020. Here again, the Supreme Court applied the Shashwa principle. Here, the wording of the arbitration clause was that the venue of the arbitration proceedings would be XYZ, right? So, because it was said that the venue of the arbitration proceedings was so and so, the court said that this meant that the parties intended to actually anchor the arbitration proceedings at that particular venue. It was not only one hearing which was to be held, it was the entire arbitration proceedings which were to be held at that venue. And therefore, that venue was considered to be the seat of arbitration proceedings. Because though the word venue was used, the Supreme Court said that this would actually mean the seat of arbitration proceedings. In this case, the Supreme Court laid down a 3-condition test as to when the venue can be construed as a seat. So the first is that the arbitration agreement should mention only one place. So the arbitration agreement should mention, for example, that the seat of arbitration is Mumbai. The venue of arbitration is Mumbai. Such place, the second condition is that such place must have anchored the arbitral proceedings without any scope of change. So the intention of the parties to anchor the arbitral proceedings to that particular place should be very clear from the wording of the arbitration clause. And finally, the final test is that there must be no other significant contrary indicia that show that the place designated is merely a venue and not the seat. So once these 3 principles are applied, the court can come to a conclusion as to what was the intention of the parties. Did they intend to select the venue as a particular place, or did they intend that that would be the seat of arbitration? And therefore, the consequent law of that seat would apply. Or the courts having supervisory jurisdiction over that place would have supervisory jurisdiction over the arbitration. In 2020, there was a decision of the Supreme Court in the case of Mankasu Impex Private Limited versus Air Visual, where again the BGS SGS Soma principle was followed by the Supreme Court. Here, the Supreme Court laid down another important principle that the arbitration agreement must be interpreted holistically. So, what is meant by that? What is meant is ultimately what the courts are doing is interpreting the intention of the parties. Because as we saw earlier, Section 20 requires or stresses on party autonomy or the agreement of the parties. So what the parties intended has to be given effect to. So all of these principles which we are looking at are principles of interpretation of contract really, where the court is trying to interpret looking at the various parts of the contract or the different parts of the arbitration clause to interpret as to what was the intention of the parties, where do the parties want the arbitration to be seated, where do they want the venue to be held, and depending upon what the court feels is the interpretation, the court will decide as to what the venue will be and what the seat of arbitration. Then another important decision was the decision in the case of Inox Renewables versus Jayesh Electricals, which again followed the Supreme Court decision in BGS SGS Soma. I'm pointing out all these decisions because for a person who wants to really understand the concept of seat and venue clearly, going through all of these decisions will be very useful, and it will be useful to understand how exactly the Supreme Court of India has interpreted these concepts. And then we come to a recent decision in November 2024 of the Supreme Court in the case of Arif Azim versus Micromax Informatics. In this case, the Supreme Court analyzed the evolution of the law on seat and venue and set out certain principles. So first, of course, the Supreme Court said that if explicitly the seat has been determined, then of course that must be followed. Otherwise, the Shashua principle has to be followed, which I discussed earlier. The Shashua principle that the venue may also be treated as the seat if there are no contrary indications, and it is indicated that the parties actually want to anchor the arbitration at the place which they call the venue. Then the Supreme Court said that if the curial law, which is the procedural law of a place, is mentioned, if the parties say that the curial law of this particular place would apply, then that would be a strong indication that that place is actually a seat. The next principle which the court said is that the court must give weight to the intention of the parties, of course, right? As I said earlier, the court is only interpreting the contract. What it is doing is it is giving in weight, or it is interpreting what the parties intended to do. Then suppose there is no express designation of seat. Suppose even looking at the other factors, the court is not able to determine as to what the parties impliedly agreed would be the seat. Then how does the court decide? Then the third principle comes into effect, which is called the closest connection test. The Supreme Court said that the closest connection test must be applied in such a case. Now, what is the closest connection test? The courts in such case will determine as to which jurisdiction has the closest connection to the dispute, to the parties. Which system of law has the closest and most real connection with the transaction or dispute between the parties? And then the court will say that the place which has this closest connection would be the seat of arbitration. But this, as I said, would be only if there is no express or implied designation of the seat. Now, suppose there is no express designation of the seat, there is no implied designation of the seat, and applying the closest connection test, the court comes to a conclusion that there are two or more places which equally appear to be the seat. Then how is this court supposed to decide as to which will be the seat? Because whatever it does, it says it could be either of these places. In that case, the Supreme Court has said that the doctrine of forum non-convenience is to be applied. What does this doctrine mean? This means that the court will decide which is the most convenient forum and take that as the seat of arbitration. So it will consider the convenience of both the parties. It will consider the law which is applicable, etc. And what the ends of justice require, what is most convenient, and it will determine that to be the seat of arbitration. And finally, very recently, in fact, on 18th of March this year, the Supreme Court came out with another case of Disortho SAS versus Merrill Life Sciences Private Limited. I would urge all of you to also go through this decision. This decision follows the case of Arif Azim, which I just discussed. And in this, again, the Supreme Court follows a three-step test, which was developed by the Court of Appeal in England in the case of Sula America. So, according to this three-step test, which was determined in Sula America, the law governing arbitration is to be determined by making a three-step inquiry. First is there an express choice? If not, second, is there an implied choice? Here, as stated in the Arif Azim case, the Shashua principle will be followed to see what the implication is. And finally, the third principle is the closest and most real connection, which again the Arif Azim case has mentioned. So here, I'm just mentioning that the Disortho case, the Supreme Court followed the three-step test which was set out by the Court of Appeal in the case of Sulame. So this is as far as the Supreme Court is concerned. But again, because there can be so much ambiguity in determining what is the seat and the venue, because the parties can be often ambiguous in setting out their clear intention. There are decisions which seem to be slightly contradictory, which come from certain high courts. And possibly when these decisions go up to the Supreme Court is when there would be a finality to what the seat of arbitration should be in these cases. So, for example, there is a decision of the Delhi High Court in the case of Hunch Circle Private Limited versus Future Technology Private Limited. This was in the year 2022. Here, the seat of arbitration was specifically held to be Delhi. But the court said that it would not have supervisory jurisdiction. The Delhi High Court said that it would not have supervisory jurisdiction over the arbitration proceedings, though the seat was specifically said to be Delhi, because the clause, the agreement between the parties also contained a clause that the courts at Guwahati would have exclusive jurisdiction over the arbitration. So the court said, the Delhi High Court said that because there is an exclusive jurisdiction clause which gives jurisdiction to the courts at Guwahati, though the seat is mentioned as Delhi, it would be Guwahati which would have jurisdiction. This is slightly again contrary to another decision in the case of Reliance Infrastructure versus Madhyanchal Vidyut Vitran Nigam Limited, which was in the year 2023. Here, the court said that if there is a generic exclusive jurisdiction clause and there is a seat of arbitration determined, the court will determine the seat based on where the arbitration is anchored, which is usually the seat, and it will ignore the generic exclusive jurisdiction clause. So basically, what the courts are doing is trying to give effect to party autonomy and give effect to Section 20, which gives party autonomy and gives parties the right to determine what the seat of arbitration will be and what will be the law governing the arbitration in case of international arbitration, and which will be the courts which have jurisdiction. Now, if there is ambiguity in a contract in determining as to what is a seat or what is a venue, then what are the issues which may arise? One of the main issues which could arise is that multiple courts may start claiming jurisdiction. So here, in this case, which I just told you about, in the Hunch Circle case, the Delhi High Court said that Delhi High Court does not have jurisdiction because the seat is, though the seat is mentioned as Delhi, the exclusive jurisdiction clause says that Guwahati will have jurisdiction. So therefore, the Delhi High Court said that it will not have jurisdiction. Now, suppose the Delhi High Court had interpreted it to mean that Delhi has jurisdiction because the seat is mentioned as Delhi. And one of the parties went to Guwahati, and the Guwahati court said that the exclusive jurisdiction clause says that Guwahati will have exclusive jurisdiction. Therefore, the seat of arbitration is Guwahati. So this would really lead to a problem in how the issues are to be resolved under the Arbitration Act, right? Would the Delhi High Court have jurisdiction, or would it be the Guwahati court which would have jurisdiction? So this multiple courts would be claiming jurisdiction in this case. And what could this really lead to? This would lead to prolonged litigation. Naturally, this would cause delays. This would cause increase in the costs. And ultimately, what would this do? This would undermine the efficiency of arbitration as an effective alternate dispute resolution mechanism. So the whole idea why arbitration is chosen over litigation is because it is considered to be a faster, more efficient manner of resolving disputes. If there are ambiguous clauses in an arbitration agreement or in a contract between parties as to seat or as to venue, then naturally this will prolong the arbitration process, and that will undermine the efficiency of the arbitration itself. So with this, if I can give you some tips on drafting arbitration agreements, what would those tips be? Precise drafting is absolutely essential. So you must draft with precision when the contract is being drafted. So you must clearly mention the seat and the venue. For example, you can say the seat of arbitration shall be in New Delhi, India. The venue of arbitration shall also be in New Delhi. In some cases, the venue may be. You must clearly distinguish the venue from the seat to avoid ambiguity in case you decide to have the seat and the venue at different places. You can say, for example, in this case, that the venue of arbitration proceedings or the venue of arbitration shall be Mumbai, though the seat of arbitration shall be New Delhi. This is very clear, explicit. So there is no question of interpretation. Second is avoid using the seat or the words seat and venue interchangeably. So when you mean seat, please use the word seat everywhere. Do not use the word venue. Use the seat. Use the word seat. When you mean venue, use the word venue. That be very clear in your draft. Third is ensure that there are no conflicting jurisdiction clauses. So in the same example of Hunch Circle case, there were conflicting clauses because one clause said seat of arbitration is Delhi, another clause said that the exclusive jurisdiction is given to courts in Guwahati. So if there, the draftsman of the contract had said that the seat of arbitration is Guwahati and the exclusive jurisdiction of the courts at Guwahati will apply, then that would be very clear. There would be no question of any ambiguity. There would be no confusion. The parties could clearly go ahead and go and apply to the Guwahati courts for any interim relief for Section 34, etc. And finally, I would say that you must consult all these judicial precedents for guidance. So this is the reason why I actually pointed out all of these important judicial precedents, because once you go through all of them in detail, you will understand exactly what the concepts of seat and venue are. You will understand how the courts interpret arbitration clauses, how they determine what the seat will be, what the venue will be, and accordingly, you will be in a better position to draft your arbitration clause. Now, what must a party think of before deciding on the seat and venue? What would you advise your client? How would you advise your client to determine the seat of arbitration when you're drafting a contract, when you're putting the arbitration clause? If arbitration is considered to be an efficient and a faster method of dispute resolution, then if courts are too interventionist, if they constantly intervene in arbitration, then that would again slow down the process of arbitration. Correct? So if the parties want to proceed with arbitration at a very fast pace, then they may be advised to choose a jurisdiction where the courts refrain from intervening too much in the arbitration. So there are, if you look at judicial precedents, there are some jurisdictions where the courts tend to interfere more in arbitration. And there are some jurisdictions which have the hands-off approach, which say that courts will have minimal intervention in arbitration. So therefore, it may be necessary for a party to choose, in the interest of efficiency, to choose a jurisdiction which is a minimal interventionist jurisdiction. Then again, if your party is an Indian client, then he may prefer India because there are certain benefits of having the seat in India. The cost, it is cost effective if you have it in India. Again, a party who is an Indian party may be more familiar with the Indian legal system, maybe more comfortable with the Indian courts. So therefore, it may, in that particular case, decide that India must be the seat of jurisdiction, seat of arbitration. And one kind of disadvantage of having India as the seat of arbitration, which is obvious, is the pendency which our courts have, right? So it is very common knowledge that litigation in India takes its own time. It doesn't take place as quickly as it would take place in a place like, say, UK or a place like US. So therefore, if a party, for example, wants to have urgent interim reliefs under Section 9, it might find it easier to apply to a court in UK or US rather than applying for a court in India. Not that the courts in India are not effective enough, they are as effective, But because of the pendency of litigation, it may not be as fast as getting interim reliefs in, say, a country like UK or US. So that is also a consideration which you must keep in mind while advising your clients as to what the seat of arbitration should be in an international arbitration. So with that, I will just leave you with one final thought, which is that choosing the right seat and venue isn't just a formality. It is the foundation of effective arbitration. And as litigators, mastering these nuances will set you apart in both domestic as well as international disputes. Thank you. With that, we come to the close of our lecture. If there are any questions, I'll be glad to take.
Thank you, Sneha, for such a wonderful webinar. Participants, in case you all have any queries, use the raise hand function or post your queries in the chat box. Let's be quick with that, please. Sneha, there's one question. Which country, according to you, internationally is an appropriate place for arbitration?
Yeah, sorry, I've muted myself. Yes. So this is a question which is not easy to answer. This would depend on who the parties are, where the parties are located, what is convenient for them, etc. But if you consider, a lot of people select Singapore as the seat of arbitration, and UK is also one of the preferred choices.
Okay. There's a participant raising hand, just unmuting him.
Good evening, ma'am. My name is Sumit.
Yes.
In maritime arbitration, you normally see that the seat and the law which is preferred is either UK or Singapore, because UK and Singapore law are, you can say, it is more precise or it is more productive. So in spite of having the parties in India, so if at all both the parties are India, but they still prefer the arbitration seat to be in UK. And the second thing is, in some contracts, I think it is only decided by one of the parties that this is the contract and the arbitration place will be, say, XYZ. So it is not mutual in that sense. So can you throw some light on it? I mean, if we are...
I'm sorry, I didn't understand the question. Can you repeat that?
Yeah, say supposing the contract says that the seat of arbitration is ABC, but I want it at XYZ. But
you are one of the parties to the arbitration.
Yes.
The contract says that the seat is ABC, but you want it at some other place.
Yes, but but it is more of the bargaining power that which governs this thing as to, okay, if you want to do a contract with me, this is the this is how it will work.
So it is only at the time of negotiating the contract can you decide on what the seat of arbitration is going to be, because I mean, if it is already you're negotiating it and you put it in the contract, once the parties have put it in the contract and is signed by both parties, it is not going to be really possible for one of the parties to say that, I do not want this seat, I want some other seat. So while negotiating the contract, of course, as you said, the party with higher bargaining power would be in a position to dictate terms. So therefore, it would probably be in a position to determine as to what the seat will be. And the parties determine commercially or decide commercially whether it makes sense. And if it does, then they accept it. And if it doesn't, they do not. But after it has already been agreed upon, it is not possible to really change the seat of arbitration.
Okay. Thank you.
Thank you, sir. Next participant.
Hello. Yeah, I'm just student and actually studying arbitration.
Okay.
Particularly, I raise a query regarding this. Just you discuss a case regarding seat. It is at Delhi and jurisdiction. Actually, the contract says jurisdiction should be at Guwahati High Court.
Yes.
So whether it is clearly, particularly a drafting error, and maybe whether it is curable or irreparable or non-curable.
So if you're asking if the court can change the clauses of the contract, that's not possible. So there is no possibility of there being any curable defect or something, because a contract is what is agreed upon between the parties, right? So once that is agreed upon, the intention of the parties can be understood by the court only by reading the contract. So
Right.
the job of the court is to interpret what the parties intended.
Mhm.
Then the court will try to see how to harmoniously construe the two clauses which seem contradictory and to see what is the actual intention of the parties. So in that case, the court came to a conclusion looking at the contract as a whole that the parties intended that Guwahati will be the seat.
Means that court has actually repaired or cured that defect.
It is not really curing the defect. The court has interpreted the contract. Though there were contradictory clauses, the court tried to decide on the basis of the contract as a whole. The court decided what was the intention of the parties, and in the opinion of the court, the intention of the parties was to have the seat of arbitration at Guwahati. So, therefore, the court held that the seat will be Guwahati.
Yeah. Okay. Thank you. Thank you. And second thing, this particularly the question of applicable law. This number of time actually it has been seen in now, which is actually main issue in arbitration. That is non-signatory parties. When in the process of making such parties to arbitration proceedings, so the question of application of that law or particularly what law should be applied to interpret such circumstances. Now it is being particular means concern for this proceeding, arbitration proceedings or litigations. So whether
when non-signatory parties are made part of the contract, what will be the law applicable? What will be the seat? That is what you're saying?
yeah.
Okay. So, first of all, we are not really covering the topic of non-signatory parties being made part of the contract here. That's a different topic altogether. But in the case of Cox and Kings, which was a recent decision, the Supreme Court did say that in certain cases, non-signatory parties also could be held to be part of the arbitration. So in such case, it depends on the intent of the parties to bind non-signatory parties also. So therefore, if ultimately the court comes to a conclusion that non-signatory parties are also bound by the arbitration, then they would be bound by the same provisions. So the same provisions of seat will also apply to the non-signatory parties. It cannot be anything else.
Cox and King is specifically for the means group of companies. There are certain means instance where non-signatory can be proper party of proceedings. Means other like implied consent apparent.
Yeah, as I said,
So,
we are not covering the topic of non-signatory parties here today. I just gave you the example of Cox and King to say that the Supreme Court in the Cox and King decision does allow non-signatory parties in certain cases to be made party to the arbitration. And in such cases, the question which you asked, which was relevant to the topic, is as to what will be the seat of arbitration.
seat problem, right?
The seat will be the same.
Okay. Thank you.
Thank you, sir. Sneha, is there any criteria for selecting an expert as an arbitrator?
Sorry?
Is there any criteria to select an expert as an arbitrator?
I don't know what is meant by that question. Again, that is not covered by our topic. But
Yeah.
Really speaking, if you're asking me this question, my answer would be that there are no criteria for determining a person as an arbitrator. Two parties can decide on any person to be an arbitrator, and that person, by agreement of parties, will become the arbitrator. But that is not really covered by our topic today.
Okay. Sneha, unmuting a participant.
Yes.
Rohan.
Good evening, ma'am. Ma'am, I have a query regarding, ma'am, in an international arbitrational dispute, ma'am, which law does the venue matters or the seats? Suppose as you said in the first example, ma'am, the two parties, one is from Mumbai and other was from New York, and the venue was in Paris, and the seat was Singapore. So, ma'am, Singapore's law will be applicable for the arbitral proceedings, or the New York or the India's law? Which law will be applicable for the procedure?
It will be the law of the Singapore court, because Singapore, as the seat of arbitration is Singapore, correct? So the Singapore law of procedure will govern the arbitration proceedings.
So, ma'am, it depends completely upon the seat, which seat they choose.
It's the
So
seat.
that law,
In
that country is
international
probably
arbit-
applicable.
in international arbitration, the law of this, the procedural law of the seat of arbitration is the law which will govern the arbitration procedure. That is now very firmly settled.
Okay, well, thank you, ma'am. And ma'am, in domestic, the India's law will be applicable, won't it, ma'am? Arbitration Act.
In India, as I said, the Arbitration and Conciliation Act will apply throughout India, correct? So if you select a place as a seat, it only gives exclusive jurisdiction to the courts having jurisdiction over that place, over that seat. So therefore, if you have to make applications under the Arbitration Act to a court, you will have to make them to the court which has jurisdiction over the seat of arbitration.
Okay, thank you so much, ma'am. Thank you, ma'am.
There's one query in the chat box. What happens if the arbitration clause is silent about selecting a seat?
Right. So Section 21E, this I'm talking about domestic arbitration. Section 21E tells you which court would have jurisdiction. If you look at Section 21E, it says that the court which would have jurisdiction over the cause of action, if the proceedings had been suit proceedings instead of arbitration, will be the court which will have jurisdiction. So if the parties have not decided at all on what the seat would be, and one of the parties wants to file an application, say under Section 11, then it can file that application to the court which has jurisdiction over the place where the cause of action has arisen.
Sneha, one question not related to today's topic, but a very basic question. Can matters pertaining to intellectual property rights be referred for arbitration?
I'm not too sure. I'm not too sure they can. They are probably non-arbitrable, but this again is not related to our topic, and I'll have to check up on this.
Okay. The next question is, do strong influential parties have a say? No, 1 second. The English is wrongly. Wait, I'll just interpret this. I think the participant is asking Sneha if there is a strong influential party on the opposite side and they choose the jurisdiction. So will they harass the other side with regards to the seat?
Will they harass the other side, meaning what? If a party, see, now this is ultimately about your commercial bargain, you know. So if you're entering into a contract with a party, knowing fully well that that party is in a stronger position and that party can dictate terms, then you have taken it upon yourself, no? So then you should be aware of the consequences of what will happen in case there is a dispute and in case the matter goes to arbitration. What will be the consequences? So if the lawyer advises his client clearly that today, you know, things seem okay, but if there is a dispute between the two of you and arbitration will be in the seat which has been chosen by the other side, these are the consequences. Then, after considering those consequences, if the party decides that no, I do not want to go ahead with this because I don't want to take this risk, the party will not sign the contract. But on the other hand, if the party feels that all right, this is a risk I'm willing to take, it's all right, I will let that party, you know, have the upper hand in the arbitration proceedings or in the seat of arbitration. And then I'll go ahead with the contract because the contract is more important to me. I do not mind taking that risk. Then in that case, the party will go ahead. So ultimately, it is up to the lawyer to advise his client correctly.
Okay. Sorry, Sneha. Again, there's a question. Can an arbitrator be a person from other profession and not an advocate?
Yes.
Okay. Sneha, there's one question. Can an action be instituted against an arbitrator who reveals information which is confidential and that he came to know during arbitration proceedings?
This again is not concerned with the topic. I think people have a lot of questions on arbitration. Yes, there is a provision for confidentiality in the Arbitration Act, which is Section 42 A. But what are the effects of an arbitrator not keeping the proceedings confidential? Are not really provided in the Act. and I'm not aware of what action can be taken against an arbitrator who does not maintain confidentiality.
Okay. So I think Sneha, we are done with the queries. So Sneha, can we conclude the session?
Yes.
Thank you so much, Sneha, for such an illuminating webinar. We really can't thank you enough for your contribution to our platform. We appreciate your contribution, and always you are just there accepting our invitation to speak. So really thanks.
You're most welcome, and it's always a pleasure to come and give a lecture on PLEA. So thank you for inviting me.
Thank you. See you. Bye-bye.
Bye.